Thank you, Mr. Speaker. Mr. Speaker, oftentimes I have made reference to the intent of our government to change the statutory and legal architecture of our country as our country transforms into one of the most modern and fastest growing economy in this hemisphere. And we have repeatedly brought bills to this House designed to meet the exigencies of those changes. Today, Mr. Speaker, like the bill that we just debated that addressed the important issue of our river and sea defense, today I present, sir, for second reading, a bill of equal magnitude. Mr. Speaker, it is now an undoubted fact that Guyana is the fastest growing economy in this hemisphere. As a result, there is an astronomical increase and expansion in almost every sphere in national life. Likewise, there's an explosion of commercial activities and an expansion in the commercial and legal sector that is unprecedented. Since 2020, we have begun the overhaul of our entire legislative and institutional tapestry in order to accommodate, facilitate, and foster these transformational changes. This bill, Mr. Speaker, is part of that changing architecture. In this ever-expanding commercial environment, contracts are executed on a daily basis, both at the level of the state as well as in the private sector, involving billions of dollars in commercial undertakings. These contracts with both local companies as well as international corporate giants. These contracts are with both local companies as well as international corporate giants. They are modern, sophisticated, and commercially efficacious. Invariably, they provide, as modern contracts do, for the resolution of disputes which may arise between parties to the contracts. In contemporary commerce, litigation has long been relegated to an option of last resort. Arbitration has replaced it as the most preferred method of settling commercial disputes. Unsurprisingly, almost every contract of the type to which I am referring contains what is called an arbitration clause. That is a clause by which the parties agree to settle their disputes through arbitration. We have an Arbitration Act in Guyana, sir. It was enacted in 1916 and is the 1889 Arbitration Act of the United Kingdom. It is therefore 135 years old. It was only amended twice, in 1927 and in 1931, almost 100 years ago. Without doubt, our statutory arbitral framework is one of the oldest in this part of the world. Naturally, it is completely anachronistic, ancient, and unsuitable to meet the demands of today's commercial environment. In this regard, we are lagging behind the rest of the Caribbean. The Cayman Islands, the British Virgin Islands, Jamaica, the Bahamas, Barbados, Bermuda, Trinidad and Tobago, and every other Caribbean territory have modern arbitration statutes. In the circumstances, we have to update our laws, not only to provide for the modern legal mechanisms to settle disputes by arbitration, but also, and perhaps of greater importance, to make Guyana an attractive destination to be chosen as the seat for arbitrations arising not only from contracts executed in Guyana, but an arbitration center for the Caribbean and perhaps even South America. The arbitration industry is a multi-million-dollar industry and has the potential of creating many jobs, most importantly, high-paying jobs. This bill seeks to satisfy all those requirements. Mr. Speaker, currently as I stand here, I can refer to already in the public domain reference being made of a potential dispute between the government and Exxon in relation to cost oil being referred to an arbitration. There is some sort of dispute between two operating oil giants in Guyana, and reference has already been made that it may be referred to arbitration. We have, sir, ongoing in Washington, the parking meter dispute. That is at arbitration. When the APNU, AFC was in government, they sold rice farmers' rice to Panama to the tune of 7.5 million US, never collecting payment for that sale. We in government had to refer that matter to an arbitration in Paris. Fortunately, that matter was settled. It was published in the newspapers as well, sir, that in the oil and gas, in the gas to shore project, some dispute has arisen or is likely to arise between the contractors, and reference has been made that it will be referred to arbitration. I give those examples, sir, so that members of the House can relate immediately to the need for a modern arbitration architecture in our country. As I have indicated, sir, our arbitration network is over 100 years old. There are certain key features of arbitration, sir, that make it stand out as the preferred mode of settling commercial disputes. And I have tried to chronicle them very briefly. Arbitration, sir, is consensual. That's the first thing. The parties must agree that should a dispute arise, it will be resolved through arbitration and not by another mechanism. Hence the relevance and importance of the arbitration clause. Secondly, the parties have the freedom to choose their own arbitrator or arbitrators, as the case may be. Thirdly, the arbitration, if the parties wish, can be a confidential process with no disclosures of the proceedings. Fourthly, the decision of the arbitral tribunal is final and binding upon the parties in the same way that a court order is binding. The procedural and evidential rules of arbitration, sir, are far more relaxed and simple than in litigation. And also, arbitration is a far more expedient, efficient, and flexible process and is not subject to elongated processes of appeals and challenges. They are very narrow grounds upon which you can challenge an arbitration. So, sir, those reasons aggregate in today's world to make arbitration a far more attractive option than litigation, where the parties lose control of the process and the process becomes the subject of the judiciary. Here, the parties have greater control. They know who the arbitrators are, they can regulate their own processes, and they have a whole host of flexibilities that the litigation process does not offer. So this bill has a particular history, and I want to share the history of this bill with this House. Mr. Speaker, the bill commenced with it being a CARICOM model arbitration bill. The Caribbean region has obviously seen the need to modernize the arbitration regulatory framework in the region. In particular, because we are moving now in the corporate component of the single market and economy. And there is a need recognized by the heads for us to have harmonized legislation, in particular in the commercial arena. And that's why, sir, in addition to a common model legislation on arbitration, we are working on a common model legislation in company law, in bankruptcy and insolvency, in trademark, in partnership, and in many other similar commercial undertakings. So this is a CARICOM model that we commenced with. The CARICOM model, sir, embraced the United Nations Commission on International Trade Law, UNCITRAL, rules regarding arbitration. So anyone au fait with commercial arbitration would know that once the bill or the Arbitration Act is patterned against or is predicated upon the UNCITRAL rules, they know that that jurisdiction has what is considered to be the gold standard in terms of arbitral or arbitration legislation. So that was adopted by the CARICOM model, and we inherited that. Then at the level of CARICOM, they looked at various arbitration legislation existing in the region and outside of the region, especially where you have blocks like the European Union, etc., and when there is a need to have a common arbitration regulatory framework. So they looked at countries such as Singapore, France, and Switzerland. And sir, these are considered the arbitration capital of the world. And the CARICOM model borrowed from those jurisdictions as they prepared the common bill which they have passed around in the rest of the region. Trinidad was the first country to implement and enact the CARICOM model bill, and that was done last year. We could have followed suit last year and promulgate our bill, but we went on a different course because we wanted a superior bill. And I say so, sir, with the greatest of respect to the CARICOM model, as it is a very good model. Sir, we began first a consultation exercise in Guyana. And we consulted widely with various stakeholder organizations, including the Bar Association, the Private Sector Commission, and the judiciary. And we enlisted their input. Then, sir, we hired a consultant, Professor Justice Courtney Abel, who did a workshop titled Guyana, the Next Arbitration Hub. And that workshop was held jointly with the Attorney General Chambers, and we invited participation from across the Caribbean. And we also received a lot of inputs from that exercise. Then, Mr. Speaker, as we go along in these different incarnation of consultations, we amend and adjust the bill accordingly. We then established, Mr. Speaker, a unit within the Legal Affairs Ministry, headed by yours truly. It had on it Deputy Solicitor General, Deputy Chief Parliamentary Counsel, a member of the private sector, a member of the Berbice Bar Association, and a member of the Guyana Bar Association. And we went through another examination of the bill. The bill was then passed to the Law Reform Commission for their input as well. Finally, Mr. Speaker, we engaged two international law firms who have extensive practice in the area of commercial arbitration internationally. And the two law firms are Gibson, Dunn and Crutcher and Arnold and Porter, based in the United States and the United Kingdom. And they reviewed the bill in its entirety and sent back to us a report containing their recommendations. We examined that report, we distilled the recommendations, and many of them are incorporated in the bill. And then, Mr. Speaker, we began a capacity building exercise because we want this law to kick off immediately because there is a great demand for it. And we started to do training. So we held a series of training workshops. For example, lawyers from Gibson, Dunn and Crutcher came to Guyana, having studied the bill. They came to Guyana and they held seminars. I remember going to one at Grand Coastal Hotel where we invited lawyers in the private sector. We invited the private sector businessmen who are interested, members of the bar. I believe the judiciary was there, the Attorney General chambers attended, and we had a workshop there. Then, through Caribbean Impact Justice, we held another training session titled Drafting Arbitration Clauses, a Practical Workshop. This workshop was open to young attorneys at law and other interested persons 40 years and under. And it was widely attended again, and experts from across the Caribbean administered the training program. In May 2022 and in June 2022, another workshop was held under the title Roadmap to Implementation of a New Arbitration Law for Guyana and Other CARICOM countries. This was a workshop arranged again by the Attorney General Chambers in collaboration with Impact Justice, and we had about 4 professors from the Caribbean. From University of Ottawa, we had Calvin Hamilton of Arbitration International and the president of the Chartered Institute of Arbitration, Caribbean branch, Mr. Miles Weeks. They conducted that training session. In March 2023, 30 lawyers again benefited from another workshop in relation to this arbitration generally, with particular emphasis on the bill. So, Mr. Speaker, not only is the bill comprehensive, but the preparation that was engaged in before the bill was brought here was also an embracing one in terms of getting the widest possible input from experts in the field, as well as building capacity in Guyana so that when the bill is implemented, we will have a cadre of persons who are acquainted with arbitration specifically and are acquainted with the bill itself. Mr. Speaker, I have also asked the Department of Law of the University of Guyana to put arbitration as a core course in the LLB program at the University of Guyana, because arbitration is here to stay. Mr. Speaker, the bill is a very involved bill. It's large number of clauses, and it would be impossible for me to go through clause by clause. So what I've done is simply to summarize the various parts of the bill to just identify and highlight the key elements. So part one of the bill, Mr. Speaker, provides for the object and scope of the application of the bill. The main objectives of the bill are to encourage the use and facilitation of arbitration when solving disputes, obtain fair and speedy resolutions of dispute, and recognize and enforce arbitral award. This part stipulates that the law will apply to domestic and international arbitration, where the seat of arbitration is in Guyana. This part also provides that the court shall not intervene in arbitration proceedings except as provided by the Act. Additionally, this part provides that certain functions relating to arbitration assistance and supervisions shall be performed by the appointing authority. For the purpose of the Act, an appointing authority includes a person, the court, international organization, or arbitration center. These fundamental functions include intervening and resolving issues such as where the parties are unable to agree on the appointment of an arbitrator is challenged, or an arbitrator fails to act. So, Mr. Speaker, I want to pause here to explain the international flavor that runs thematically through this bill, because it is intended. This bill creates a very flexible environment, so it allows for parties to go to arbitration by themselves. It allows for the court, during the course of a case, to refer a matter to arbitration if the contract that is the subject of the litigation has an arbitration clause. And then it also allows for an arbitration or a company offering arbitration service any part of the world to come to Guyana to locate and offer that service. And that flexible infrastructure is a key part of the bill. So, Mr. Speaker, for example, as I have said, I've cited two examples, but there are many, many. When one if you read the contracts that we are signing every day in Guyana, all the contracts have an arbitration clause, and it refers the arbitration to London, to Brussels, to Paris, to New York, to Washington. And why? I mean, those are metropolitan centers. But all the arbitration is governed by is the Arbitration Act and the conduct of the parties. We can have that done in Guyana if we have the same framework. And this bill creates such a framework. Mr. Speaker, you may be aware, members of the House would know obviously of the oil spill in the Gulf of Mexico. That was BP, that horrible disaster. It involved an arbitration, or resulted in an arbitration involving hundreds of millions of US dollars. That arbitration was done in Nassau, Bahamas. Nassau, Bahamas can fit several times in Georgetown, Guyana. So if we have the type of infrastructure here, the regulatory framework here, the edifice, the services, we may have to import personnel, and that's why we have begun the training process. But eventually, we will be able to build capacity here, but in the meanwhile, we have the freedom and we have the arrangements necessary and the framework requisite for the biggest arbitration center to come here, occupy a building, and render its service. And that is what this bill does. So on the short term, it tries to make Guyana self-sufficient in arbitration. And then in the long term, it intends to make Guyana an attractive arbitration destination. Mr. Speaker, Part 2 of the bill governs arbitration agreements. An arbitration agreement shall be in writing and can be in the form of an arbitration clause. This part allows the court, where an action is brought in a matter which is the subject of an arbitration agreement, to refer the parties to arbitration unless the court finds that the agreement is null, void, inoperative, or incapable of being performed. Moreover, this part provides that the court may, by order, refer a matter other than a criminal one to arbitration, if necessary, irrespective of whether the parties consent. Further, this part provides that it is not incompatible with an arbitration agreement for a party to request before or during arbitral proceedings from a court an interim measure of protection and for a court to grant such measure. So you may have an arbitration, sir, and one party may need an injunction or some form of interim protection, which the arbitration center may not be able to grant. In that event, there is a flexibility again. One of the parties to the arbitration can go to the court, get an interim order to protect whatever the status quo is until the hearing and determination of the arbitration. And so that type of flexibility runs throughout the bill in a common way. Part 4 of the bill, Part 2 of the bill governs the arbitration, Part 3 of the bill deals with the composition of the arbitration tribunal. And the parties have the freedom, as I said, to choose the number of arbitrators, and where there is no agreement, the number of arbitrators shall be 3. The parties are empowered to determine the procedure for the appointment of an arbitrator. Additionally, where the parties to the agreement fail to appoint an arbitrator within 30 days of receipt of a request to do so, the appointing authority shall appoint the arbitrator. This part lists the grounds for challenge or grounds for challenge of a person's ability to be impartial and an independent arbitrator. So obviously, you have a mechanism by which one of the parties can challenge an arbitrator on limited grounds, and that's why you can't have spurious challenges. The grounds are actually limited, and even strong evidence has to be produced to support challenges, so you don't have frivolous and vexatious objections raised to a particular arbitrator. Part 4 of the bill provides for the jurisdiction of the arbitral tribunal. An arbitral tribunal may rule on its own jurisdiction. This part also provides for the parties to make pleas concerning the jurisdiction of the arbitral tribunal and sets out the process for raising such a plea. The arbitral tribunal can continue with proceedings while the pleas on lack of jurisdiction are pending. So, Mr. Speaker, obviously, any tribunal must first satisfy itself of its jurisdiction. And there are provisions in the bill that would allow any person, to the arbitration, of course, to challenge the jurisdiction of the arbitration, so that the arbitration cannot act outside of the authority conferred upon it, either by the act or the parties by their agreement. This act also contemplates and provides for mediation even within arbitration. And this is another component of the flexibility to which I am referring. So it is contemplated, and experience has shown that even in an arbitration itself, as informal comparatively as it is with litigation, and despite the parties having the flexibility and the discretion which they have, there are sometimes going to be impasse that can affect the arbitration from continuing. This act provides for a breakout. Put the arbitration on pause and go to a mediation, an even softer approach, an even more flexible approach, an even more informal approach to ensure that that particular issue that is causing some deadlock is resolved. So mediation is part and parcel of the arbitration process. Part 6, speaks to interim measures and preliminary orders. I already made mention of the fact that if during an arbitration, despite all the powers that the arbitration commission may have, the arbitration tribunal may have, if in the event that they don't have that repertoire of power that is particularly required, or that remedial power that is particularly required to address something that may have arisen, they can go to the court. But they do have, under the Act, a repertoire of remedial powers that will allow them to grant such orders as they see fit in the circumstances to meet the justice of the particular cause. So Part 6 provides for interim measures and preliminary orders. This part empowers the arbitral tribunal to grant interim measures and set out conditions under which an interim measure may be granted. One of these conditions is that the requesting party shall satisfy the tribunal that the harm not adequately repairable by an award for damages is likely to result if the measure is not ordered. The same injunction test. If you're going to suffer irreparable harm or damage, then the damage that you will suffer will not be compensated in the final analysis or in the final decision of the arbitration tribunal, then you would have demonstrated a case for an interim stop measure. So whatever it is that you are claiming is causing the harm. A very similar test for interim injunctions. The Act confers that statutory power on the arbitral tribunal to grant such orders as it see fit. A request for an interim measure coupled with an application for preliminary order preventing the frustration of the purpose of the interim measure may be made without notice to the other party. So there is a provision for an ex parte application to be made. This part also provides for the recognition and enforcement of an interim measure, requiring the party seeking the recognition and enforcement to notify the court of any modification, suspension, or termination of the interim measure. So if you get the measure there and you have difficulty in enforcing it, remember this is a tribunal, it doesn't have the plenitude of power and resources that the High Court would have through its systems of marshals, etc. You can take that interim measure, go to the court, and ask the assistance of the court to enforce it. All of that flexibility is in the bill. This part also provides that the court shall have the same powers to enforce interim measures in arbitration as it has in relation to proceedings in the court. So if you go and you register that interim measure and there is a breach, you go back to the court. If the tribunal doesn't have, the arbitration tribunal doesn't have the power to enforce the order, you have a resort to the court. So you straddle, you get the best of both worlds. You have the court to enforce all your orders, to correct all the deficiencies and inadequacies that the tribunal may have, and you have the coercive power of the court. So if an interim order is granted and it's being violated, and the arbitration center doesn't have the power to enforce it, you go to the court and you get the whole repertoire of contempt of court redress available to you. Part 7 of the bill provides for the conduct of the arbitral proceedings, and it sets out all the procedures. All the parties shall be treated with equality and given a full opportunity to present their case. Obviously, the parties have the liberty to agree on the procedures to be followed by the arbitral tribunal in conducting the proceedings. I spoke about the freedom to regulate it oneself. The parties have that. To this end, the parties also have the liberty to adopt the UNCITRAL arbitration rules. You will see at the back of the Act, the UNCITRAL arbitration rules are attached. And as I said, those rules are considered the gold standard. So if the Act is anyhow deemed by any party to be inadequate, well, then you have the UNCITRAL rules there to supplement it. And the UNCITRAL rules have been enacted since in 1985, and it has served the commercial world with distinction since. The parties will also decide the place of the arbitration. However, where there is no agreement as to the place of the arbitration shall be determined by the arbitral tribunal having regard to the circumstances of the case, including convenience of the parties. So that is why I'm saying that they can choose Guyana. And we have given that latitudinal freedom in the law. Additionally, this part provides for consolidation, which may occur when the court believes that a common question of law or fact arises in all of the arbitral proceedings, or where the rights of the relief claim when the proceedings are in respect of or arise out of the same transaction or a series of transactions. Lawyers will know about this power. It's a power to consolidate a number of different proceedings so that you can have them disposed of conveniently and with efficiency. The arbitration, the Act confers upon the arbitration tribunal the same repertoire of powers. A lot of powers that a court will have in the conduct of a litigation are conferred upon the arbitration tribunal by the Act. Part 8 of the Act bill deals with award and termination and provides for the making of an award and the determination of the proceedings. Here, this part sets out the power to make the orders that are being prayed for, etc., how they will, and how the judgment will be delivered or the decision will be delivered, etc. It deals with such incidental issues such as costs, and again, where there is any deficiency, the Act allows the parties to rely upon and enforce the UNCITRAL arbitration rules. It provides importantly for interests and how interest, for example, is to be calculated either by compound interest, simple interest, etc. So all those powers that the court would have in making a decision and in granting consequential orders, the tribunal is invested with those powers. And then part 9 deals with recourse against the award. As I said, any award made by any tribunal must have some ground upon which one can challenge it. I refer to the limited number of grounds here, but it is provided that an award can be challenged. Obviously, if an illegality occurs, if one party commits some illegality in the course of it, or it's subsequently found that one of the arbitrator misbehaved in the decision by accepting bribe from one of the parties, obviously that must be a basis for setting aside of an award. An award may be set aside in certain instances, for example, where proof is furnished that a party to the arbitration agreement was under some incapacity, or where the agreement is not valid under the law. Setting aside may also occur where the court finds the subject matter of the dispute is incapable of being settled under arbitration laws in Guyana. So if the issue could not have been arbitrated in Guyana, then obviously there's a ground for setting aside the award. So these are the three grounds. Fraud is, I believe, a fourth one. Then part 10 deals with recognition and enforcement of the award. Obviously, one gets an award and goes through a long process to get an award so that they can be able to have it recognized and enforced appropriately. The bill deals with that. It covers the recognition and enforcement of award. An award shall be recognized as binding and shall be enforceable. The award may be refused only where information is provided that the party to the arbitration agreement was under some capacity, etc. And obviously, you can go to many jurisdictions in the world and have that award registered as an order of that court in wherever you want to enforce it once it's recognized as a valid award. Part 11, Your Honor, deals with the miscellaneous provisions of the bill. I will not go through all of that, Mr. Speaker. So, Mr. Speaker, this bill is a historic intervention in a very important area, and it adds to our legal system a very important adjunct. And that adjunct is a modern way of settling disputes outside of the court system. We have another bill which we'll be debating later this afternoon, dealing with plea bargaining. That's another form of settling disputes in the criminal justice system. Here, it is in the civil justice system. I say that to you, Mr. Speaker, so that you have a clear picture of the magnitude of the modernization that is taking place in our legal and regulatory architecture. And why we are doing all of this? Because we have an economy and a country that is developing at an amazing pace. We have companies that are huge, considered corporate giants. They have a lot of resources at their disposal. Our country and its people can benefit from those resources. So we have to keep whatever their business is. They must not come here alone to benefit from our resources. But if ever dispute arises, we must not give them the opportunity of exporting resolution of those disputes to another country, and we have all the facilities here. We must ensure, because at the end of the day, buildings are going to be rented. Our staff, our people are going to be employed. Our lawyers eventually will become skilled and experienced arbitrators. And when the foreigners come, they stay here, etc. As I said, arbitration is a multi-million-dollar commercial exercise. Ask any company that has gone to arbitration or any person who has functioned as an arbitrator. Very, very remunerative undertaking for all involved. So, Mr. Speaker, this is not a bill that I anticipate any opposition to. I invite my friends on that side to give this bill their full support. Thank you very much, Mr. Speaker.